started in just a moment. Let me know, Mr. Moya, and by the way, good morning, sir. Let me know when you're ready to proceed, sir.
Good morning, Mr. Chavez. Will do. We're working on it right now.
Ms. Fella, how are you?
I'm good, thank you. How are you?
I'm well, thank you. Thank you.
Mr. Chavez, we are now live.
Okay, good. Okay, folks, good morning. My name is Stephen Chavez. I am the Land Use Hearing Officer for the City of Albuquerque. Today's date is June 2nd, 2021, and we are here on two appeals which I have consolidated because they concern the same property, the same facts, and essentially the same issues and the same parties. I note that the appeals are AC-21-6 and AC-21-7. And let me see, hold on a second. It looks like there's something going on with my computer. Fixed it. Okay, can everybody hear me okay? Thank you. Okay, so AC-21-6 and 7. And I note that the appellant, who is the Sycamore Neighborhood Association, supplemented the record today or yesterday with a copy of a case from the Court of Appeals, the New Mexico Court of Appeals, the Downtown Neighborhood Association versus the City of Albuquerque. I'm very familiar with the case. Who is here with the downtown with the Sycamore Neighborhood Association? Who is representing the Sycamore Neighborhood Association? Hello? Who is the appellant in this case? Are there any appellants?
Okay,
in this case?
I'm sorry. I'm technically not trained to do this. I apologize.
No worries. Well, and you are Miss Martin Gardella.
Martin Gardella.
Okay,
Yes.
Miss Gardella, you are the appellant in this case, correct?
Yes.
And
Yes.
you are here on behalf of the Sycamore Neighborhood Association?
Yes, I am.
Okay, I will have to swear you in before you begin. I wanted to ask you a question though. When you provided a copy of that case law, it's not a factual issue, it's essentially a legal issue, but did you provide a copy to the party opponents?
Yes, I did.
The applicants of the ZHE?
I did.
Okay, good. Thank you so much. I will include that in the record for the City Council. I'm sure they are all quite familiar with that case as well. So
I was pretty sure that everyone in the city was familiar with the case. I just wanted to supplement.
No. Hold on. Right, I understand. I need to swear you in before. Who is here representing the party opponent? Ms. Negrete?
Yes.
Good morning.
Good morning.
Are there any people that are going to testify other than Miss Gardella and Miss Negrete?
Probably Joe Grady.
Mr. Grady. Okay. Good morning, Mr. Grady.
Good morning.
Okay. Anybody for the appellants, Miss Gardella, other than you?
No.
Okay. Good. Well, everybody who is going to testify in this hearing, please raise your right hands so that I can see them. Great. Do you affirm to tell the truth, the whole truth, and only the truth under penalty of perjury?
I do.
I do.
I do.
Thank you. Okay. So, Ms. Gardella, go ahead and proceed. I may interrupt you occasionally to ask you questions. Okay?
Fine. Thank you very much, Mr. Chavez.
And I've read the entire record, just so to let you know.
Okay. Before discussing the variances, I'd like to address the issue of neighborhood notification. Sycamore neighborhood was notified of this project in December of 2020. Neighborhood members participated in a video meeting on January 19th of 2021. We were not, however, notified of the filings for the variance or of a hearing date before the ZHE. Knowing the project is proposed is not the same as being notified of the hearing. I know I can't prove that I wasn't notified, nor Mr. Richard Vigliano, who is the other neighborhood person, but neither of us got notification of the hearing date or the filing.
Now, Ms. Gardella, let me interrupt you. I'm looking at the record on page 062 and 063 of the record, and I can tell you that there are certified mail return receipts that were sent to the Sycamore Neighborhood Association representatives. Now, under New Mexico law, all that is required is that they send notification, certified mail return receipt. Whether you have received it or whether the Sycamore Neighborhood Association representatives received it or not is really not my concern, because they have met the criteria under New Mexico law. The notices were sent, and the reason, the policy rationale of that law essentially is that people can be duplicitous and claim they didn't receive it when they did receive it. So under the law, if they can prove that they've sent the mail, certified mail return receipt, they've met the criteria under the zoning ordinance and under state law. Okay. I
may be in error. I may have missed it somehow. I could not find that receipt in the file, but that's okay.
Page 62 and page 63 of the record.
Thank you very much.
Go ahead.
Okay. We appeal these decisions because we believe the ZHE erred in approving the variances. The New Mexico Court of Appeals in Downtown Neighborhoods Association versus the City of Albuquerque stated, the purpose of a variance is to prevent zoning regulation from operating to deprive a property owner of all beneficial use of his property. A requirement for approval of a variance is that the applicant must show the property to be exceptional. Quote, there are special circumstances applicable to a single lot that are not self-imposed and do not apply generally to other property in the same zone district and vicinity, including but not limited to size, shape, physical characteristics, natural forces, or by government actions for which no compensation was paid. Such special circumstances of the lot either create an extraordinary hardship in the form of a substantial and unjustified limitation on the reasonable use or the economic return on the property, or practical difficulties result from strict compliance with minimum standards. It is the burden of the applicant to prove a variance request meets the criteria for granting approval. Ms. Negret did not show how this property is exceptional. In both the application and in the testimony, she refers to the property being exceptional because of a slope, a grade change. At no time does she indicate what the grade change is on the only part of the property that is planned for development. The only reference is to an 18-foot grade differential across the entire site. However, the high point in the topography is outside the area of the building location. There is no other argument to support exceptionality of the property. These variance requests are based on the slope being exceptional. The ZHE relied solely on the agent's statements in the application and at the hearing that the property is exceptional. There is no evidence in the file that statement is accurate, quite the opposite. All the photos in the file, including the owner's own pictures, show a lot that is not handicapped by a major grade change. All photographs show a moderately sloped property. It is the responsibility of the ZHE to review all the information in the file and to compare the accompanying photos and site plans with the statements made in the application. On January 17th, prior to the neighborhood video meeting, Ms. Negret was asked by the neighborhood representatives for a site plan with measurements because the information she supplied to us was indecipherable. That's on page 52 of the file. She never complied with that request. The variance applications have no readable measurements, in particular, no topography elevations. However, the site plan that Ms. Negret used at the hearing and that the ZHE asked her to submit to the file shows readable topographical lines for the property. I refer you to page 107 of the file. This is the site plan that she used. Ms. Negret indicated in the application and stated at the hearing that, quote, because the topography changes, we will be about 14 feet higher than the 30-foot requirement, end of quote. 14 feet is not an insignificant variation from the IDO requirement that no portion of a building within 100 feet of a protected lot be over 30 feet in height. Ms. Negret's statement, quote, "We are asking for this variance so that our building can have a higher height on the side that faces the more commercial and higher density uses," end quote. The photo on page 98 shows the commercial buildings she is referring to, ones with the same zone as the lot she is proposing, they are proposing to build on, are only the commercial buildings across the street are only 2 stories high, not the 3 stories they're proposing to build. The residential properties on the north, east, and south are primarily 1 story. It is not in line with the rest of the neighborhood. A view of the topographical lines on this site plan submitted after the hearing shows a 5,071-foot elevation at the south property line at the west side of the proposed building. The elevation directly north at the north end of the building is 5,075 feet elevation. That would indicate about a 4-foot grade change north to south on the land the building is to sit on. There is only a 2-foot elevation across the south property line at the front of the proposed building, from 5,071 on the west side to 5,073 on the east side. These small elevation differences do not justify a variance that would allow a 14-foot difference in height than what the IDO allows. Nearly every lot in the vicinity has some sort of grade change, many much more severe than 4 feet. In the pre-application review meeting notes, agent question number 3 states, quote, "Fire stair encroaching into rear yard and neighborhood edge buffer," end quote. The neighborhood understood at the video meeting in January that the staircase and storage were reason for requesting a 15-foot rear yard setback. This is referenced on the 2nd page of Laurel Schilke's letter. The justifications in the application and the hearing testimony do not refer to the staircase as being in the rear yard setback. We must assume that the fire stair is a required element of this building. The site plan on page 107 shows the fire stair is in the rear yard setback, yet Ms. Negret never mentions this fact in the application or in her testimony. The topographic lines indicate about a 1-foot elevation difference in this area. Completely accurate measurement is not possible because the topography lines are partially obscured in the area of the building plans. However, the fire stair in the setback is not a result of the slope of the property being exceptional or creating a hardship, but rather of the building being too large, too long north to south to fit on the property.
Ms. Gardella, may
Yes.
I interrupt you a second? And
Yes.
more time, certainly. When you said that the staircase is in the setback,
Yes,
in the rear of the building, are you talking about the north side of the lot?
the north side of the building,
Okay.
yes.
Okay, good. Thank you.
In the rear yard setback, yes. The fire stair in the setback is not a result of the slope on the property being exceptional or creating a hardship, but rather of the building being too large, too long north to south to fit on the property. The agent stated at the hearing, we'd like to put some storage down there, end quote. A storage building is not a necessity. It is not a hardship to avoid building a storage building. A variance is only appropriate when there is no other way to develop a lot. A 15-foot rear yard setback variance is not necessary in order to build on this property. The grade change is not sufficient to be a hardship to development. This owner will not be denied all reasonable use of the land or experience an unjustified lack of economic return if these variances are denied. Thank you, Mr. Chavez.
Thank you. I have a few questions. Ms. Gardella, your
Yes.
appeal is for all of the variances, all 4 of the variances that were
No, we only could afford to appeal 2 of the variances.
Now, I saw that in the record, and did the city planning staff try and charge you for each appeal?
I was told that I had to pay
Wow.
$130 for each appeal.
I'm going to consider all 4 variances because I don't think that that's appropriate. I think you have a right to appeal all 4 variances. the ZHE treated all 4 variances in one consolidated hearing. They were never separated out. And so I think, and nobody complained about that. So I believe that it's appropriate to include all 4 of your appeal issues that you raised in the
I
argument.
have not addressed the others because I was told that we had to appeal each of them individually and pay $130. Which-
I'm going to deal with that. You can make arguments on all 4 appeal issues,
Okay.
just as you made to the ZHE.
I stand on the record of the letter that I submitted for the neighborhood association in regards to the other two applications for the decisions on the other 2 cases.
Okay.
The wall and the neighborhood, the 20-foot setback, landscape setback.
The edge buffer, the
The edge,
buffer.
yes, the edge buffer. Thank you.
Are you finished, Ms. Gardella?
I
don't
am.
have any-
I'm finished, but I do get another 10 minutes or something for a rebuttal.
You absolutely, and of course you do. So, but my question was, are you finished presenting your?
I am finished with what I have to say. I felt the
Before you speak, let me finish speaking so that we can just get one person on the record at a time. Ms. Fella is a court reporter and she needs to make sure that she gets every word, okay? Good, okay, so with regard to the wall permit variance, I'm not sure what that was. Do you have anything that you can help me on what that was?
Are you asking me?
Yes, Ms. Gardella.
No, one of the preliminary questions I asked in my letter to the ZHE, what are raised to the ZHE, was that there was nothing in the file justifying the wall, not even where she was talking about.
Yeah, I don't have any, I don't understand what the wall permit major, I read the IDO regarding the wall permit major under section 57D, and I'm just, I suppose I can ask the applicant. Thank you so much. Now, Ms. Negrete, you can cross-examine Ms. Gardella. You can ask her questions if you like, if you have any questions for her. Do you have any cross-examination questions for her? Not argument, just questions.
No, actually, I don't have any questions for her.
Okay, now you're subject to cross-examination by Ms. Gardella, and certainly take all the time you need to present your case. I have a lot of questions with what the ZHE approved, so I'll try to reserve those for when you finish. I tend to interrupt people, and I apologize for that, but if I don't interrupt, I will lose my train of thought. So I will be polite, though. Go ahead, ma'am.
Okay, so our understanding is that the challenge is against how the ZHE interpreted our presentation. But what I'm hearing today is that there's some questions with respect to the information that we provided. So I will keep my comments focused on that. And then if there's additional comments or questions that you have with respect to how the ZHE interpreted what we presented, I'm happy to address that. So I'm hearing 2 particular points, one with respect to the topography, and the second with respect to what was presented at the neighborhood association meeting. So I'll address the neighborhood association meeting first. We were emailed, I guess, the night before we were to meet with the neighborhood association, a request to have a dimensioned drawing. And I responded that we didn't have enough time to prepare that because I think that request was made to me on a weekend and I was actually out of town. The next morning when we had a meeting, we walked through all of the dimensions with the site plan. And I don't think that I understood at that time that any additional information was requested. So although I know that they did request that prior to the meeting, it was my understanding that at that meeting, all of their questions were satisfied. So that's the first thing I wanted to address. The second thing I wanted to address was talking about the exceptionality of the site. So the site itself has a slope in the area that is buildable that is, I believe, about 5 feet, as she has indicated. However, what we're claiming as exceptional is the fact that there are 7 feet on the eastern portion of the property that are being retained. And the elevation of that particular edge of the property, and I can't look at my site plan because I'm here on you, but I believe that it's at about 5082. And at the bottom of the site in the back corner, it's at 5075. And we're saying that that's an exceptional case because we are being held to developing this property at a protection height. So we are restricted in height to 30 feet when the property adjacent to us is about 10 feet higher and can develop up to 26 feet. And so our building would essentially be held to a lower height standard than the property directly, the protected lot that's zoned R2 to the east. And that doesn't seem like it's meeting the requirements or the reasons behind that exception. So that's the reason on the height that we consider this to be an exceptional lot. We are not allowed to have a development height that the property adjacent, the protected property, can have. On the other side,
can I just stick with that first?
Sure.
I have some questions regarding that. I kind of thought that was the case when I read the record. I couldn't really, I kind of speculated that was the case. I didn't see that quite well developed in the record. The variance would allow you an additional 15 feet, so you would be at 45 feet?
I think the total height is 44 feet. I don't have the drawing in front of me again, but it is below the maximum height that would be allowed. We would be meeting the protected height on the side of the property that is adjacent to the RT.
So you would be meeting the protected height of the property based on the elevation of the protected lot?
Correct.
Okay, so you're using the protected lot to measure the height of what is allowed, essentially.
I actually think technically we're using the height of the property, the site subject property on the east side, not necessarily the height of the property next to us continues to increase in grade to the east. So it's even higher than our property.
So I guess the issue is that the way that I've interpreted the variance criteria, literally for 17 years now, 16, 17 years, and the city council has approved that interpretation in their decisions, is that there has to be a nexus, essentially. There has to be the exceptionality of the property has to essentially cause the hardship, the extraordinary circumstance. And of course, it can't be self-imposed. But there has to be that nexus. But for the topography, you have a need to build to this height. And I didn't see that nexus in the record. Can you describe it for me? Because it seems to me that you could, just because, I mean, for argument's sake, the protected lot is higher. How does that create a hardship to the lot that you're developing, or the owner of the lot that's being developed?
The hardship in general because of the topography, is a drainage condition that has to be mitigated by that retaining wall that is on our eastern side of the property.
So building up would mitigate the drainage problem?
No, sorry. I think I was trying to address a different portion of your question. So
Okay.
maybe you could just restate your question one more time and then I can address
How
it.
does building higher resolve the exceptional circumstance? How does that mitigate the exceptional circumstance of the topography? It seems to me that there is a valid question that you are trying to obtain these variances, including the height variance, because you want to overdevelop the land. You want to build a more dense building, essentially, and put more parking to I guess to deal with the denser, the larger building. So I mean,
Okay, I think I understand what you're asking.
Okay.
So the topography wasn't the only condition that we said was exceptional on the property. I think that's just kind of what's been focused on in the appeal. The other issues that are exceptional are that the site is in an area of change. This is a comprehensive plan zoning designation that is intended for a higher density, higher residential use. All of the properties on this block and the block to the east are also zoned as areas of change. This project meets.
But that's not a zoning designation. That's
No,
a
that's a comprehensive plan.
Right.
Yes. So the hardship is that this property and this block are all zoned incongruent. So the properties to the north are of a higher density residential. This property is a zone consistent with a lot of the zones to the east. And then we have several lots of RT zoning.
So you're claiming that the IDO itself is creating the hardship.
Yes, in
Now,
particular.
I can tell you that issue has been litigated before in front of me. And I wrote a very lengthy recommendation to the city council stating that you can't use the IDO for that purpose. Otherwise, the exception is swallowed by the rule. And so I can tell you that I will find against you if that is the basis for the exceptionality.
Well, I'm just saying that there's a hardship on the property when there's an incompatibility with the area being zoned an area of change and the entire block being zoned an area of change, and then having another additional layer of requirements on that property that relate to protected lots that don't recognize the fact that you can meet the intent, which we are meeting the intent by not exceeding the height limitation on that side. Where we're not meeting the intent is on the west side, where there is no requirement to have that particular height. And the zoning code having parking requirements is not intended as a way to control density. It is a way to control parking. And so I don't think that that is an argument that the neighborhood association can say that we are overbuilding on the lot, because parking is not a way to control development. And if this particular lot were 150 feet in any direction to the north, or I think to the west, we would be in the transit exception where there wouldn't be the parking requirements.
Where does that transit exception fall? Where does it stop?
It falls, I believe, halfway through the block to the north. I don't have that in front of me, but I can provide that information. But the Presbyterian Rapid transit stop is located due north.
And those are parking exceptions. I'm familiar with that. You can.
Yes, those are parking exceptions. So the intent of parking has not ever been to minimize development impact. In fact, the majority of the language in the ordinance on parking defers to reducing to minimum of the requirements. So therefore, if you have a fraction, you're supposed to round down. The idea is in no way trying to increase parking to minimize development on the lot. So I don't think that the fact that we're trying to meet the parking requirements is any part of this discussion, because that's governed by the use of the property. So if you have more residential uses, your parking requirements are going to be different than if you have office uses. So they're to meet the needs of those uses, and they don't really have any actual impact on how you would overbuild physically, square footage wise, on the lot.
Okay, so I'm sorry, we're dwelling on the height issue. There's 3 other variance issues.
Okay. I only was prepared to talk on 2 of these, but I'm happy to address the others. So as far as the rear setback, the storage buildings would be allowed if they weren't connected to the building, because they would be an accessory unit and detached. So building in the rear setback is permissible. We are asking to have it attached to the building in order to support a terrace, a yard that would be accessible and landscaped and provide amenities to the building, and alleviate some of the drainage and ponding issues that would happen in that rear corner of the site. Previously, there was a building in that area that was part of the original medical office building. That footprint is still visible on the site. And so previously the drainage was mitigated in a different way because there was a building on that site and it was roof runoff. Now it will be ground. It will need to be dealt with on the ground because that area is no longer permitted to be buildable. So the intent was to have the storage, which would be accessible from the parking area, and it technically is below grade. And then the rooftop of that storage area would be a landscaped yard for the building. So that's kind of how that area is being developed.
I apologize to interrupt, but with regard to the appeal, the argument that Ms. Gardella is making regarding the rear setback in the accessory structure is that the accessory structure there's really no relationship for a variance and the extraordinary hardship for this accessory structure. That is, it seems to me you're claiming that the drainage issue is impacted by not having the structure. I don't see that connection. So if you can elaborate on that connection, I don't see it.
Okay, so I think what I'm trying to say is that it's acting in lieu of putting fill in the site. So in order to develop that portion of the property, or in order to mitigate the drainage onto the property that is coming from that northwest corner of the topography, there will be water entering that site from the adjacent property and from the alley to the north. So that area of the site would require to be regraded in order to accommodate that water, because a building is no longer on that piece of the property. There previously was a building, and that was able to prevent some of that water by taking it onto the roof and moving it forward. Because that is no longer an option to build on that site, because that has been removed and the new zoning code requires that 15-foot setback, that area would need to have some sort of ponding, fill, a way to deal with that drainage. And so we are saying that that is a hardship on the site because that ponding, that water is not being derived from the site. And so in order to come up with a
I didn't see any engineering studies showing that in the record. I mean, it seems to me that there needs to be a minimal amount of evidence to substantiate that. You're making a very detailed argument that is unsubstantiated by facts. I didn't see anything in the record. So that's a problem.
Okay.
I'm not convinced that that's the issue. I mean, I'm not saying you're being dishonest.
right.
I just don't see the evidence in the record, and I don't see it. I know how to read site plans.
Mhm.
Been doing it 25 years. I don't see that in the site plan. I just don't see that connection.
Okay. Well, I mean, I think the actual question is whether or not we actually need this variance. I have not seen anything in the IDO that regulates what can happen below the grade. Technically, as I was saying, we were thinking that this would be below the grade. This is detached technically from the building. We were recommended during our PRT to have this as a variance. But our understanding is that it's a storage building, it's accessory use, it is allowed in that setback as long as it's not attached to the structure. So we can try and figure out how to move forward with this particular storage area without attaching it to the building.
Can you describe for me the wall permit major? I read the idea. I've never dealt with the wall permit major before. So it's a learning experience for me. What is the variance for that? Is it a height variance of the wall, or is it a setback variance?
This might be a better question for planning staff. So when we applied for the variance and went through the PRT process, it was recommended to us that we apply for both a variance and a wall permit major. And since that application, I have applied for several other wall variances, and I am not exactly sure if the criteria has maintained the same as to whether or not that was needed. The variance is in particular to the front wall that's already existing.
The retaining wall? Is that a retaining wall?
Yes, so it's retaining in the south east corner. It's retaining that 7 feet of property that is at a higher grade into the site. So it's existing. Now, my client wishes to alter that wall by making some openings into the wall so you can see into a courtyard and to re-stucco it. And we've provided images of how that wall would be modified. And we were advised in the PRT that because we are modifying the wall, we're not taking it down, we're not adding height to it, we're not moving it, we are merely improving its aesthetic, that we needed to request a variance for that. But the intent is not to build a new wall, the intent is to keep the wall, and the wall in a certain portion of that is necessary for retaining.
So the variance is to construct it or to reconstruct it, essentially. Is that what the variance is for? I'm misunderstanding you, I think.
I'll let Joe speak a little bit more clearly to this.
Mr. Grady?
I'm in complete agreement with everything Michelle is saying, but I know that old building, and that front wall variance is to allow a wall, as far as I understand, higher than 3 feet. We want to have a wall 6 feet. But the structural reason that we wanted to keep that wall as high as we could in the southeast corner is because it ties into the existing retaining wall that runs north-south on that east wall. So my hope was that we wouldn't have to try to redo any of that existing retaining wall. There's a corner there that would be compromised if we had to tear that whole wall down. It's an existing block wall on that south side. So we're in my eyes, it's more structural than aesthetic. But to make the aesthetics better, we wanted to cut holes in, not holes, but slots, some kind of nice looking wall. But structurally, that southeast corner would be affected if we took that wall down to 3 feet, which would the reason we need the variance is to keep the wall as high as we can.
Okay. I wish that evidence would have been in the record. And I don't know if that was your fault or the ZHE's fault, but I honestly, I don't know what the variance was for. And he doesn't distinguish what the variance is for. He just calls it a wall permit major variance. I don't know what that means. I mean, it could mean anything. And I was thinking it's under the new exception that was in the IDO change in 2019, or went into effect November 2020, which allowed for height variances if in properties, commercial properties, mixed use properties, that it can be shown that there's additional crime and things like that. So it is a height variance. Okay, and I think I understand the necessity of that. I just didn't see that in the record. So I can reweigh that evidence. So
Yeah, we were asked to submit for both the wall permit and the variance. So they were two separate processes.
So the wall permit major is separate from the variance.
That's sort of my understanding, but like I said, it was a bit unclear as to how that application process was required and what triggered what. And like I said, in applications that I've done since, it's still not super clear. I think that there's some confusion as to, I think there's sort of a threshold where a wall permit major is allowed. And then if you exceed that criteria, you're required to have a variance. But
that's what you think this is.
This is clearly a variance because it exceeds the wall permit major requirements. But why you have to submit for both, I'm unclear on.
Again, okay. Okay, now with regard to the fourth variance, the 20-foot variance for the edge buffer, can you explain the rationale for that and the basis for the nexus between the necessity of the variance and the extraordinary or the special circumstances of the property?
I think that the basic exception was that buffering requirement was applied after the site had already been developed. And so we have already had parking. The parking plan is not changing. And so what we're trying to kind of do is maintain what the site has already been permitted to do and has been developed since the 50s, and that the edge buffering requirement doesn't allow for that to be maintained. We're actually meeting the edge buffering requirement on, I think, 2 or maybe 1.5 lots. The property is divided into 3 lots. So the exception is really for a small portion of the site. And that allows us not to have to change where the curb cuts are. And we don't have any access from the alley because of the topography. The alley is at least 2 to 10 feet higher than the site. So we can't use that as an access to the site to change the parking configuration.
I can see that would create essentially a practical difficulty, which is the lesser of the criteria in that first prong of the analysis. I mean, it's the easiest to obtain a variance by proving the practical difficulties. The problem is that there is literally a lack of evidence, a lack of factual findings of the practical difficulty or of the substantial unjustified limit on a reasonable use of the property. I mean, like I said, I can speculate what that is, but it's not clear in the record. And I think that's kind of the major issue with this application.
Could I mention one thing?
Mr. Grady?
I didn't mean to interrupt.
Go ahead.
I just wanted to mention, and Michelle had mentioned this, or in I think maybe one of the other hearings, that the reason for the buffer was to protect the neighbor to the north, as far as I understand, by not having a parking lot right next to their property. But there's already an alley as a buffer. And that had been mentioned in the hearing before, that there aren't going to be cars backed up to somebody's yard. There's already an alley that acts as the buffer. But maintaining the driveways that were there in the existing building is also seems to be a pretty big consideration.
But doesn't the IDO take that into consideration for the edge buffer? There's language in the IDO, I thought, that says even if there is an alleyway, you still have to have the 20-foot buffer. Something to that effect. I mean, I'm paraphrasing, obviously, but something to that effect. So it takes that into consideration.
Okay, I'm not familiar with that alley phrase in the IDO, but that was mentioned when the application was submitted, or that in the hearing, that we were trying to protect the neighbors with this buffer zone, and they are protected by that space between the properties. But I wasn't familiar that the IDO had something about alleys like that. So
it does specifically for the buffer, for the edge buffer. I'm trying to find it now.
But we were able to, we do have a landscape plan, and we're not asking for any variances on cutting back on the amount of landscaping we have. But that existing parking lot we're keeping about the same. The footprint of the new building is very close to what the old building was.
Right, I see that. Okay. Unfortunately, though, the issue is the variance criteria. I mean, variances are not supposed to be issued routinely, and they're not supposed to be issued unless all 5 of the prongs can be met, not just 1 or 2 of the prongs. And I have a concern with the ZHE's factual findings, because they're not supported by the record. But he made very few factual findings. He made conclusions of law without factual support for those conclusions. And I couldn't find, what I'd like to do is I'd look in the record to see if there is factual support for his conclusions. And sometimes there is. And so I make a recommendation to the city council that, look, the ZHE could have found this because maybe he meant this, because there's there's some factual evidence in the record that supports this. Even though he didn't specifically find it, there is evidence in the record. But in this record, there is very little evidence to support some of his findings, and I'm just concerned with that. But I'll look harder at the record. I was trying to find that language with regard to the alleyways, and I can't. I know I read it in there, but it's, I think, on page 286 or 287 of the IDO. In any event, Ms. DeGret, are you finished with your presentation?
I am.
Because if you have anything more, I know I interrupted you probably more than a few times. Do you have anything?
No, I mean, I just to make sure that you understand, the wall height, if you had any additional questions on that, happy to address that. And I think as far as the buffer requirement in the rear, it's really an access issue.
Okay, right. I see
Joe,
that.
Joe might have something to add.
Okay.
I
Mr.
have,
Grady?
I have just one thing, just about, I mean, it does seem like a major issue on this, all the variances are whether this is an exceptional lot or not. And I don't know of any other lots in that area. There are sloped lots, but I don't know of another lot that has an 18-foot difference in that, because I think that is about what the difference from one corner to the other of the lot is. There's an existing retaining wall that we will be utilizing in the development. We don't want to change that existing retaining wall, but we also want to be able to use the strip of land that is above that retaining wall that is part of the property. I know the building won't be on that strip of land, but we are intending on landscaping it and having tenants be able to use that space if we're allowed to do our plan as we see fit. The lots to the west are two-story buildings, and that was mentioned by Mrs. Gardella. But those are so unlike the lot that we are trying to develop because they're relatively flat. Our lot is it is totally different from those lots. So that does seem to be kind of a big issue. Whether this is an exceptional lot, I think that it very much is.
Mr. Grady, the exceptionality of the lot is really not the only issue.
I know.
It's the opening issue, because if you can show that the lot has some exceptionality or some special circumstances attached to it, those special circumstances have to be the basis for your variances. That is, you can't develop the lot you can't reasonably use the lot because of the special circumstances. There has to be that nexus, that connection.
Sure. And the way the former building was, we could not use that 7 feet that was north of us. We had no access to it. We could jump on the roof of that building, but it was fenced in. We have not had access to that strip of land, or did not have access to that strip of land when the other building, the other medical building, was there in place. So we were denied that land before we came up with this new plan.
I have a question regarding the wall, the height variance. What part of the wall was the height variance for? Was it the north or the southwest corner?
Only it goes across the south, and that wall is existing. There is right today, there is a block wall that used to be part of the old medical building that's up about, it's still got the parapet on it. It's probably 10 feet tall. But what we are for security and mostly for the structure of that one corner. And that was kind of tied in. It was mostly for the structural part of that one corner.
And how long was that variance going to? I know it's 6 foot in height, but how long was it going to traverse?
All the way across. I believe it's all the way across the facade of the south side. So there would be it would go across along Cole Avenue, right? Which is and we could say, well, because of traffic or this and that, but I mean, structurally is what I'm thinking about.
Okay. And I note that the variance for the height of a wall has changed considerably. That is, you don't have to prove the 5-prong test. It's basically they can practically do it administratively. There's a huge exception for it. under the ordinance. And I think you fall under that ordinance. Again, I'm just concerned that the ZHE didn't make any findings regarding that. So, we're all left to guess what are the limits, the parameters of the variance. And I mean, I suppose I can deal with that. I could step in his shoes. I don't like to step in his shoes. I have the authority to do that. I have the discretion to do that. And sometimes it's necessary rather than just, sending it back to the ZHE on that issue, in that particular issue. So I might consider that. Now you are subject to cross-examination, Ms. Negrete and Mr. Grady. Ms. Gardella, do you have any cross-examination questions for Ms. Negrete first? And
No, I do not.
Before she starts, could I just add one more thing?
yes, hold on, Ms. Gardella.
I'm sorry.
No, it's okay.
I'm never sure if the hand is seen here. The other hardship that I wanted to just mention that the topography creates, if we're not allowed to go to the height that we're requesting, on the west side of the property, there's no sunlight, there's no daylight. The grade change blocks all of the natural lighting into the building site. And that is why Mr. Grady removed the previous building, because he couldn't get tenants to rent the building because it was too dark. And so the intent was to raise the building and allow more natural light into the building to make it leasable, because without that, the building is essentially only lit from the west. So the site conditions really impact the ability to get natural light, to get ventilation into the building.
Is it the trees that that block the natural lighting that are
No.
on the side?
No, it's the actual grade. So if the bottom of the building is built at,
Okay, I mean, that's a novel but strong argument. The problem is that the ZHE didn't consider that argument. That wasn't even in the record. At least, I mean, I believe it wasn't in the record. I read the record over the weekend. Did you make that argument to the ZHE?
I believe we tried to show it in our elevations, but I don't know if it was explicit enough. We're trying to kind of indicate that, the way the building is designed, the light comes down into the building. And we've set it back even further than the requirement as much as we can and still meet the parking. I mean, if you look at the site plan, it is at the absolute point where the parking can be put to try and get some light into that side of the building.
Okay, I mean, that's a compelling argument, but there's not evidence in the record. I don't like to do remands. I dislike remands because all I'm doing is just overburdening the ZHE. He has tons of cases, as you know. His dockets are really full, and I hate putting this back on him, but I think that that's an issue that I would like the ZHE to reconsider. And I think it would be privy, it would be prudent for you to privy is a wrong word, I apologize. It would be prudent for you to submit evidence to the ZHE regarding that as a practical difficulty or a significant hardship. It would not just argument, evidence, factual evidence. And I think I need to remand this back to the ZHE to consider that, and then he should consider some of the other issues. And I will give detailed instructions to the ZHE unless Ms. Gardella has more information in her cross-examination. I just think it's necessary that this, and I'll give you an opportunity, Ms. Gardella. I'm not finishing here. I'm just talking about this. This is just open. I haven't actually concluded that yet. I need to look at some of the issues in more detail in the record. But it seems to me that I agree with Ms. Gardella that the record is insufficient to support a variance. I mean, the variance criteria is very difficult. It's very difficult to meet, and it should not be met routinely as the ZHE did in this case. Anyway, I'm just overblown here. Ms. Gardella, do you have any cross-examination questions for Ms. Negrete?
Yeah, I'm confused.
Just questions.
I'm confused. She's,
No argument. Don't ask me and don't make arguments to me. This
Okay.
is your opportunity to just ask questions of
Well,
Mr. Negret's testimony. Nothing else.
There is a 7-foot piece of property. There's a retaining wall on the east side of the property. 7 feet of the property is on the other side, on the east side of the retaining wall. That's 7 feet and is part of a total of a 20-foot setback that has to be maintained between the protected property on the east and the new building. I'm confused about her description of the light in the lower portion of the building. If she would tell me, would explain to me why that is a problem.
Ms.
Because
Negret, did you understand the question?
No, I'm sorry. I think she's asking about the light getting into the building.
Yes. If there is a 20-foot space on the building has to be set 20 feet back from the property line. So it's.
Hold on, Mr. Grady.
It's a requirement that it be set back 20 feet from the neighboring building. Am I correct?
There's nothing in the zoning code that says a building has to be set back from another building.
Yes.
So I'm not sure.
But I think Ms. Gardella, let me rephrase the question for you, and if I get it wrong, please let me know. There's the protected lot and the buffering, right? The 30-foot height limitation if you're within 100 feet of a protected lot.
But there's also a 20-foot distance buffer on the east side.
You're talking about a setback. There's a setback.
A setback on the east side of 20 feet. So I'm confused about the light not being able to get in if there is, because the retaining wall is not 10 feet tall all the way down.
I would need to look at the notes again, but I believe that the setback requirement by the zone is 5 feet on that side.
I don't believe that's correct.
And Ms. Gardella, you're stuck with the answers you get.
Yep.
If you disagree, that's fine. You can deal with that in your rebuttal closing, but this is just a time to ask Ms. Negret questions, not to argue back and forth.
That's fine.
I mean, I might be confused as to what she's asking, but I think the side setback is 5 feet.
Okay. Any more questions, Ms. Gardella?
No, thank you.
Any questions for Mr. Grady, Ms. Gardella?
No. No.
You hesitated. Okay. So then let's move on. Miss Lorena Patton-Quintana, do you have anything that you would like to add to the record?
No, sir, I do not.
Okay, thank you so much.
Thank you.
So Ms. Gardella, now you have your closing rebuttal.
Well, one statement I'd like to make is that if this property had not been brought down to the level of Cole Avenue and to Cedar Street, they would not be able to have a parking lot on there. It was necessary for the access to that lot. It is new evidence, and I know I can't present it, but the property across the street was not as flat as it is now. It was regraded when it was rebuilt. So the integrated development ordinance was put together over several years with many groups and individuals contributing to the ordinance. It continues to be updated to ignore the hours of planning and thousands of dollars it took to get to the regulations. Excuse me. We have to get to the regulations we have is to waste any consideration of organized planning. A variance is not a home free ticket for poor design. Again, quoting the Court of Appeals, variances should be granted sparingly, only under exceptional circumstances. To do otherwise would encourage destruction of planned zoning. Excuse me, I need to get a drink. losing my voice. Following the regulations in the IDO is what makes the planning effort worthwhile. These variances are unnecessary and undermine the intent and purpose of the IDO. If this lot creates an extraordinary hardship to development, then the newly built apartments just 6 blocks north of this property were surely built on land in need of the same variance. That block has an approximately 20-foot elevation change across the property, according to the developers. That land was regraded, the apartments designed and built to fit the lot. No variance was needed. The ZHE failed to follow the IDO by not considering the directive protecting the adjacent lot to the east. The IDO states that, quote, no portion of a building or accessory building can exceed 30 feet in height within 100 feet of a protected lot. It can't be more than 30 feet tall. By designating the RT lots as a protected lot, the IDO signals that special attention needs to be considered for the totality of the development adjacent to the protected lot. The ZHE acted arbitrarily by ignoring the evidence in the file that the grade change was not excessive. The site plan submitted at the hearing is definitive evidence that there is not an exceptional slope on this property. The agent did not give an accurate measurement of the actual grade change on the area for the proposed building or define the supposed hardship. A 4-foot grade change across the buildable area of the lots does not pose a hardship to development. This property is not unusual in size. The shape is generally rectangular. And as the site plan on page 107 shows, the physical characteristics of the land are not exceptional. There is no extraordinary hardship in the form of a substantial and unjustified limitation on the reasonable use or economic return on the property. The property owner is not denied all reasonable use of the land. There is no extraordinary hardship. This is a lot that can be built on, but with a smaller building, one that would fit more harmoniously with the other buildings near it. The ZHE erred in approval of these variances by ignoring the evidence and not following the IDO. Approval of these variances essentially changes the zoning of this property by allowing more intense development than the current zoning allows. These variances are a backdoor zone change and they undermine the intent and purpose of the IDO. For these reasons, we ask that you support our appeal and deny the variances. Thank you very much.
Thank you, Ms. Gardella. Okay, folks, thank you so much. I will have a written recommendation to the City Council within 15 days. If it's a remand, it's not a recommendation, it's an automatic remand to the ZHE to reconsider. I'm essentially teetering on a remand. I don't like remands because it just places too much of a burden on the ZHE. I can tell you right now there's insufficient evidence in the record to support the variances. I agree with Ms. Gardella. So the issue is whether it should be remanded for me. I will strongly consider it. I will reweigh the evidence and look at this issue very closely. When I submit my recommendation, it will be sent simultaneously to everybody on the Zoom list. For Ms. Ortega, when she notified you of the Zoom channel, the link, everybody on that email will get a copy of the recommendation. Okay. Thank you, folks. Thank you so much for your time. It was a good hearing today.
Thank you very much.
Bye-bye.
Thank you.
Bye.